sorry that you have left us, to be honest. And it's a great honor for us to be able to host your book launch. So it's a great pleasure to have you back. Gabriel has been an excellent colleague for CCLS for a number of years, and he has contributed along all our areas of focus. So he introduced international economic law as a program in the school. He set up the International Economic Law Clinic, and now we are one of the very few universities who actually have this type of International Economic Law Clinic globally. He was loved by his students. I have some comments that I found in past records, which I will not shame him with, but his students always spoke very highly of him, and he had some of the best assessment results, teaching assessment results in the school during the time that he was here. But he was not just an excellent teacher and an excellent point of knowledge. He was very close to his students. He was trying to create employability opportunities for them. So he had contacts. I'm sure he still has contacts with WTO, with BRD, World Economic Forum, and many others. Some of our students have done internships in these places, and it's because of Gabriel. I actually bumped into Gabriel at some point in the BRD building in London. I was going in, or I was coming out, and he was going in. So we actually bumped each other. None of us know we both have friends there, which shows how well Gabriel was connected and was appreciated and respected, not just by the students in the academic community, but also by the policymakers. So when Gabriel told us that he has to leave us, I think it was in the first year that I took over as head of school, I believe. I was starting, so I did not take it personally. I did not take it personally that you left as soon as I started, but it was really a big loss for us. I will not talk about Gabriel's research. I think he's a leading researcher in his fields. The book launch now here actually is a testament to that. But I'm very happy to see you again. We're still very proud of you. We're still very proud that you consider us part of your history and you're here with us and you honor us with this book launch. I'd like to thank the speakers who have come to actually speak and comment on the book of Gabriel. All of you who came, the ex-head of school is here, Professor Spiros Maniatis as well. Thank you so much for coming back to your old premises. Good to see you as well. So I will leave you that. Unfortunately, we have to go to a dinner, then I have to go, but I'll leave you to the panel. Thank you very much for joining us.
Welcome, everybody. I think Yanis has said it really well. We are so happy to have Gabriel back at CCLS. I am Dr. Tibisai Morgandi, and I'm a senior lecturer and professor in international energy and natural resources law. I've been at CCLS for 6 years, and with Gabriel, we share this setting up of the international economic law clinic that Yanis mentioned, which is one of the flagships of our LLM programs here at Queen Mary. And this opportunity to set this up with Gabriel allowed me to get to know Gabriel as a colleague. And I have to say, we all miss him very much. He was really not, as Yanis was saying, not just a fantastic professor, but a great colleague. And it's great that you're back with us today, and so happy to be launching your book today, Rules for Trading Services 2.0, Adapting the GATS to a Changing Trade Landscape. My area of expertise is international energy law, but I do a bit of trade. But I have to confess that I'm not an expert in trading services. But tonight, I'm accompanied by experts in this area, and I look forward to the discussion that we're going to have. And they come from government, they come from academia, they come from private practice, some work at the WTO. So really, we're so lucky to have them here today talking about Gabriel's book. I will briefly introduce the discussants and then give the floor to you, Gabriel, for a presentation on your book. So to my right, Dr. Ines Willemins is teaching fellow and lecturer in law at Stanford Law School. Ines' research focuses on the regulation of digital services under international trade law, and her research has been published in leading academic journals, and her monograph on digital services in international trade law was published with CUP, Cambridge University Press, in 2021. Before joining Stanford Law School, Ines practiced EU and international trade law as a senior associate in the Brussels office of Baker McKenzie and Sidley Austin. And prior to entering practice, Ines conducted her PhD research at Leuven. And Ines also interned at the Appellate Body Secretariat of the WTO in 2019. So thank you for joining us, Ines. I'll start with ladies first. To my left, Justine Rodier is the Deputy Director of the Services and Investment Legal Team at the Department of Business and Trade, working at the Government Legal Department. Previously, Justine was legal counselor at the UK mission to the UN, WTO, and other international organizations in Geneva. And in this role, Justine oversaw the legal aspect of the UK's exit from the European Union in the WTO. She was also the UK's representative at the dispute settlement body, including leading for the UK on discussions on dispute settlement reform. And she represented the UK in WTO dispute, and she supported the UK's participation in other meetings. So thank you for being us, Justine. And in a way, we said that in a way you stole Gabriel from us, but we do understand why you recruited him. So
your gain is all, your loss is all gain.
Exactly. Then we have Professor Panos Derimatzis, who is Professor of EU and International Trade Law at Tilburg University in the Netherlands, where he was the former director of the Tilburg Law and Economics Center. He specializes in and has extensively published on international trade law, regulatory governance, transnational private regulation, and EU internal market. Panos held visiting positions at Harvard Law School, the Max Planck Institute in Heidelberg, and several European universities. Good to have you back in London, Panos. Thank you for coming today. And last but clearly not least, Hamid Mamdou, who spent a long time at the WTO, but is currently a senior counsel at King & Spalding, and he is the former director of the Trading Services and Investment Division of the Prior to that, he was a senior counselor in the Services Division and was the secretary of the WTO Council for Trading Services since the establishment of the WTO in 1990. And during that time, he was also responsible for legal affairs in the area of trade. During the Uruguay round negotiations, his responsibilities included legal matters relating to the negotiation and the drafting of the General Agreement on Trade and Services. So thank you, Hamid, for being with us today. So we're going to hear all about trading services, but I think without further ado, okay. Gabriel, you're on.
I'm going to read. Before I say a few remarks about the book, there are people that may need to read early, so don't please be free, and no one really feel uncomfortable about that. I'm just standing on the door, like holding you, not to leave, but I will gladly let you go. So, yeah, I could not have thought of a better setting for this book launch than the Center for Commercial Law Studies at Queen Mary University. CCLS, as usually known, is where I had the privilege to be trained as research student and to work as a full-time academic for 15 years. During my time at CCLS, I benefit from the interaction with enthusiastic students and intellectually challenging, collegial, and supporting colleagues. So it was in this place where I conducted the research that now sees the light through the publication of this book. I would like to acknowledge the generous support provided by CCLS for this book launch, the logistical assistance provided by the events team, and I want to thank the CCLS director, Professor Ioannis Kokoris, for his unwavering support and encouragement. Special thanks to the discussants, three of which came from abroad, especially for this event, for taking the time to read the book and prepare some comments, which no doubt will contribute to an interesting debate about the challenges that lie ahead for the governance of trading services. And thanks to my colleague, former colleague, TV Simon Gandhi, for chairing the event. We are on your hands, TV, to make sure we are account to our time slot. And many thanks to the people attending both in person and online, in particular to former Queen Mary colleagues, students, and current colleagues from the government legal department, as well as family and friends. So let me say a quick summary of the book. The aim of this book is not to offer a commentary of the GATS. Instead, the purpose is to take the agreement as a case study to shed light on the extent to which WTO members can adapt multilateral trade agreements to changing circumstances, identify the factors that constrain the adaptation process, and consider potential pathways to overcome. Back in 1994, the adoption of the GATS represented a watershed in the history of multilateral trade governance. With the adoption of an agreement with standalone rules and principles solely for trading services, the GATT contracting parties took a bold step to close the gap between the trade rulebook and the trade landscape. But the signature of an agreement does not stop the clock. 3 decades later, the gap widened again. Today, WTO members still struggle to deliver on the GATT's mandate to secure a common framework for disciplines for trading services with a view to the expansion of such trade and the conditions of transparency and progressive liberalization. The main proposition of this book is that the GATS is an extremely flexible agreement which offers plenty of room to accommodate WTO members' rights and obligations to changing circumstances. But protracted negotiations, reluctance to cooperate, and the absence of a fully functioning dispute settlement system have prevented WTO members from taking the advantage of such flexibility in order to adapt the GATS to the current trade landscape. Let me illustrate this with 3 examples relating to digital trade, services standards, and development. First, the GATS was drafted at a time when the internet was at its infancy. Since then, digital technologies have reshaped the way we trade, what we trade, and who trades like never before. Whole sectors that once required physical proximity between suppliers and consumers can now be transacted online. In turn, digital trade is underpinned by the transfer of a staggering amount of data across borders. This begs the question of whether the agreement remains fit for purpose in a digital era. Arguably, there are no major gaps between GATS disciplines and those needed for secure, open, and non-discriminatory market access conditions for the supply of services by electronic means. The agreement was drafted in technologically neutral terms. Its core obligations can go a long way to address discriminatory treatment or market access restrictions on services supplied by electronic means. And the Annex on Telecommunication incorporates far-sighted provisions to guarantee foreign service suppliers access to and use of public telecommunication networks and services on reasonable and non-discriminatory conditions, and to protect the right to use such networks for the movement of information across borders. The problem is that these disciplines only apply in scheduled sectors, while the breadth and depth of members' specific commitments is just too modest. Thus, looking forward, the single most important task to adapt the GATS to a digital era is to negotiate the expansion of WTO members' specific commitments in those sectors and modes of supply critical for the functioning of digital markets. But this outcome remains elusive due to protracted multilateral negotiations. The book explores the case for open plurilateral negotiations to overcome the stall. Second, the GATS only assigns very limited role to international standards in disciplining members' right to regulate, and the legal framework for cooperation with other international organizations is pretty basic. However, since the GATS entered into force, we have witnessed the emergence of a growing body of international standards on services and other informal regulatory outputs driven by a rich and varied spectrum of standard-setting bodies, which have become part and parcel of a new multi-level, multi-stakeholder global economic governance framework. This too begs the question of how to adapt an agreement negotiated, monitored, and enforced within a strictly intergovernmental organization to a new landscape where non-state actors and non-state-made rules have growing incidence in the governance of trading services. The book elaborates on a range of measures that WTO members could take to adapt the GATS to this new trade governance landscape. For example, the Council for Trading Services would establish sector-specific committees tasked with identifying relevant international standards for specific sectors. WTO members could then negotiate their incorporation into the GATS via an Article 18 additional commitment. And the negotiation of these additional commitments should be supported by the provision of technical assistance to individual developing countries in need of support to participate in the standard setting process of these standards or in the meeting the implementation cost of these standards in the domestic legal system. In addition, the book points at ways for improving cooperation between the WTO, relevant international standard setting bodies, and other informal regulatory forums concerned with services in a mutual beneficial manner. Finally, GATS special and differential treatment provisions calling members to liberalize market access in sectors and modes of supply of interest to developing countries and conferring them flexibility for opening fewer sectors, liberalizing fewer types of transactions, and attaching conditions to the market access commitments made sense at a time when trading services was dominated just by a few multinational enterprises from developed countries. But 3 decades later, the participation of developing countries in trade in services rose from just over a fifth to more than 40% of world exports in services. And the service sector has become critical for sustainable and inclusive economic growth for WTO members at all levels of development. In this new context, it is questionable whether blanket flexibilities for all developing countries to undertake less than reciprocal commitments remain a suitable means for striking a fair distribution of rights and obligations among WTO members. To adapt GATS special and differential treatment provisions to this new context, WTO members could consider ways to support individual developing countries whose regulatory framework in a specific sector is not ripe for liberalization, to commit to liberalize such sectors at a future date in line with progress on regulatory reforms. The implementation of such type of commitments should be tied to the provision of technical assistance to support such reforms. There is plenty that members can do through the deliberative function to improve the efficacy of technical assistance to this effect. Looking ahead, the only certainty that we have is that the trade landscape will continue changing. There is no silver bullet for a future-proof agreement. It is for WTO members to make the most of the flexibility the GATS has to offer through negotiations, deliberations, and dispute settlement in order to keep adapting the agreement to changing market circumstances on an ongoing basis.
Very much, Gabriel. So perhaps we can start the discussion, and we're going to kick off with Ines, who's going to talk to us about chapter 5 and 6 of the book and comment. Ines, you have the floor.
Thank you, thank you. So first of all, thank you, Gabriel, for having me. I'm usually pretty secure about my knowledge on trade and services, but on this panel, I feel a bit overclassed maybe. And it's also a special kind of torture to ask someone to speak for 10 minutes on something that they wrote a whole book about. I'll really try my best. So I was asked to comment on chapters 5 and 6. So chapter 5 deals with GATS and digital trade, and chapter 6 with the related topic of GATS and data flows. And I think what the book does really, really well is that it brings together all of the contentious issues that surround digital trade. It successfully introduces the many, many open discussions that we still face when it comes to digital trade and how the GATS applies to digital trade, from the classification of digital products, whether they qualify as goods, services, to the anti-competitive practices that we see by digital actors, as well as just the fragmented way of regulating data around the world. So that's very laudable and very helpful, I think, a very helpful introduction to those readers that would otherwise not really see the forest through the trees. I think there's many ways to approach commenting on these two chapters. For today's purposes, because we only have a limited amount of time, there's many people who like to add some comments. I want to approach these two chapters from the angle of the new agreement on economic commerce that was not agreed upon, but the WTO members, some WTO members have agreed to a stabilized text at the WTO. So for 5 years, a group of countries varying, I think they started out with 70 countries, now there are 90 something countries have started negotiating an agreement on electronic commerce in the context of the WTO. It's not a multilateral agreement, it's a plurilateral agreement, only some members, but accession to the negotiation is open to all. I will pick out some of the questions that you, or some of the contentious issues that you mentioned in the chapters, and address to what extent this agreement on electronic commerce kind of deals with this issue. Because of course, the agreement on electronic commerce, the whole idea behind it was to clarify and fill any gaps that are outstanding. So one of the issues that you mentioned in the chapter is the fact that we, as scholars that discuss digital trade and services, I think almost all of us agree that the GATS is applicable to digital services. But WTO members have mixed opinions on all of this. And the agreement on electronic commerce, as it stands now, does not confirm the applicability of the GATS. It references GATS obligations, so it references the transparency obligation in the GATS, and it references general exceptions, security exceptions in the prudential carve-out from the financial services annex, but it doesn't, from that we could infer applicability of the GATS, but also it's a lot of inference and not no explicit mention. And then there's this very interesting provision, it's Article 3 of the Agreement on Electronic Commerce, where the members affirm the rights and obligations that they have under WTO agreements. So they do refer to the agreements that they all, or the WTO agreement that they're bound by. But then they also say that nothing in this new agreement shall be construed as diminishing the parties' rights and obligations under the WTO agreement. I wrote a blog post about this because I think it's a very interesting provision, because to me it seems to suggest that members are saying that this agreement on electronic commerce does not contain any WTO plus provisions because it does not add to or diminish the obligations that they already have. So that as a first general comment on the electronic commerce agreement. There's also no clarification on what a digital product is, whether a digital product should be considered a good or a service. It's understandable that they didn't take this approach because we cannot, or members cannot take a position on digital products in general, right? Whether a digital product happens to classify as a good or a service depends on the digital product at issue, but there's no mention whatsoever on how to make this distinction. There's no new market access concessions, even though you very rightfully point out in the book that what would help the liberalization of digital trade most is actually WTO members just undertaking more market access commitments, especially in the modes that are most relevant. So cross-border supply as well as mode 2. There's no clarification on how digital service needs to be classified under the GATS. We need the services classification to understand the obligations that apply, the market access and the national treatment obligations that apply to these services. So pretty crucial to clarify that. Hasn't been done in the agreement on electronic commerce. I thought it was very interesting. You mentioned in the book that the WTO Secretariat is working on clarifying the correspondence between the W120, which is an old document negotiated in the 90s, or not negotiated, put out by the Secretariat in the 90s, and the updated UN classification of goods and services to kind of see whether we can clarify the old document with new classification. I'm wondering to what extent this will be helpful, though. I'm not so sure we need a technical clarification of how to classify digital services, but more political will by the WTO members to clarify how they see all of this. But so also that is not included in the agreement on electronic commerce. There is a provision on access to and use of the internet. So you also touch upon access to and use of the internet, network neutrality in the book as one of the unresolved questions, to what extent the annex applies to digital services. So there is a provision touching upon this, where the parties recognize the benefits of service suppliers and end users that have access to services and apps of their choice, that they can connect to the internet, basically allowing for network neutrality. But interestingly enough, all parties recognize the importance of all of this. They explicitly state in the last paragraph of that provision that the parties are not required to adopt any particular measure to implement these principles, which kind of negates the whole recognition of how important this is. And then finally, when it comes to data flows, there's also no provision on cross-border data flows or mandating cross-border data flows in the agreement on electronic commerce. There's only an obligation to adopt privacy legislation, including an endeavor for this privacy legislation to be non-discriminatory. I think from a WTO law perspective, all of this is very interesting to me. There's a lot of no, we're not imposing any new obligation. So what does this agreement on electronic commerce contain in terms of more substantial or substantive provisions? It does contain a provision on trade facilitation, which you don't mention as an issue in your book, which I also don't consider to be the main issue with digital trade. It is important in its own right to make sure that there's trade facilitation, that there's recognition of electronic signatures, electronic contracts, electronic invoicing, but arguably this is not the most contentious part of digital trade. And then finally, the second element that it does, or second substantive element, is that it does contain the e-commerce moratorium. So this moratorium is basically a recognition of WTO members that they have never imposed customs duties on electronic transmissions, and that they promise not to do so in the future. This used to be a kind of statement that was made every ministerial conference. But then a couple of years ago, members started to be a bit uncomfortable with the e-commerce moratorium, querying whether they should still keep the statement going. It's not an obligation; it's just a recognition of we don't do this and we won't do this for the future. But so the members or the parties to the e-commerce agreement did include that in their in the e-commerce agreement, also clarifying that it's not only the transmission that cannot be subjected to customs duties, but also the content of the transmission, which was one of the main contentious issues that was unresolved. Unfortunately, they did not manage to make that permanent. It's still subject to a 5-year review. So to wrap it all up, because I know I'm running out of time, I think the book does really well at pointing out these contentious issues. We see that now WTO members have been discussing basically all of what you mentioned in your book. If you look at the negotiation text for the Agreement on Electronic Commerce, all of these things have come up. But then when it came to like finalizing a text, agreeing on a text, very little actually made it into the text. So you advocate for a flexible and an adaptable legal framework in your book, saying that this is an area that will keep evolving. And I completely agree with you on that. I think there's definitely a need more for principles rather than very strict and targeted digital trade regulation, because we will be caught up by the technology anyway. So I'll leave it at that, but happy to.
Thank you so much, Ines. I think great that you kicked off the discussion already, highlight some of the key aspects of the book. I might move to Justine, who I think is going to tell us a bit more about chapter 3. Justine.
Thank you very much. And thank you very much for inviting me, Gabriel, and hosting this. And I'm honoured to be here and in such expert company. Gabriel's invited me to make some remarks on the chapter of his book about the relationship between the GATT and preferential services, PSA. And before I do so, I wanted to briefly make some general observations, which I hope will help to frame my later comments. And at the start, I should also say that although I'm here, I work for the Government Legal Department, the observations I make today, I'm making on my personal trust. As Gabriel set out really descriptively in his book, the trading landscape has changed beyond recognition and beyond what could have been imagined since the inception of the GATS. But throughout this, the GATS continues to underpin the global trading system for trading services, providing a set of baseline rules which apply to all WTO members on a non-discriminatory basis. And from the perspective of the UK, we engage in support efforts at the WTO to enhance the rules for trading services and to progress liberalisation. And this is an important agenda. It's important for global economic growth, with services generating more jobs and output than agriculture and industry combined as of 2024. It's important for development, providing a direct route for developing economies to diversify their exports. It's important for the planet, given the contribution that environmental services can make to environmentally positive outcomes. This is an agenda that the UK is championing. And it's important for the UK as a global leader in services trade and the second largest exporter globally. So thank you for inviting me, and I'm really pleased here to be celebrating Gabriel's book and such an insightful contribution on this subject. But turning to the relationship between preferential services agreements and the GATS, Gabriel raises some broad questions in the book. To what extent do the commitments and treatment flowing from preferential services agreements mirror or diverge from GATS commitments, and what are the consequences of this for the multilateral system? Do PSAs create trade or do they divert trade? And do PSAs encourage further multilateral rule development, or do they inhibit it, divert it? And on this, I'd like to make 3 observations. My first observation is the conceptual approach of the GATS continues to be taken as the starting point, the building blocks for many preferential services agreements, even if it's elaborated or adapted. Most PSAs still use the basic framework of the 4 modes of supply. Most include the foundational principles of national treatment, of market access, and for many, most favoured nation treatment. And most employ the conceptual approach, the flexible conceptual approach of scheduling commitments against these key disciplines, even if the manner of scheduling does vary. But this still allows the very differently structured economies to adapt to their circumstances. That structure from the GATS remains present. As well as that, most PSAs adopt and build on the rules on transparency, requiring due process in the development and administration of measures, and encouraging or requiring regulatory cooperation to unlock trade barriers. And my reflection on this is really quite a simplistic one, that despite the new challenges and the passage of time and the changing landscape, these building blocks continue to prevail even in bilateral regional agreements, and that maybe that in itself is evidence that the GATS, with its broad scope of application and its inherent flexibility, its technological neutrality that Gabriel mentioned, is still relevant, even if the time is right for it to be enhanced. My second observation is to agree with Gabriel that there's potential PSAs, preferential services agreements, to act as an incubator or a catalyst for the development of new rules at this multilateral level, thereby assisting the development of new rules. To take an example, in 2021, WTO members concluded negotiations on the domestic regulation of services. The UK was a strong supporter of this initiative, and we've submitted our certification request to add the new disciplines. The new disciplines aim to cut administrative costs for services providers, and the implementation is expected to lower trade costs by over $125 billion worldwide. As Gabriel set out in his book, the principles clearly benefited from disciplines on transparency and domestic regulation at a regional level. And the same is true of the recently agreed, if not incorporated, joint initiative on investment facilitation for development and the e-commerce initiative. So regional development and implementation of these disciplines, I think, can help build understanding of the barriers and the means of overcoming them that can then be built on at the multilateral level. Gabriel, of course, recognises that this isn't the case on all subjects, and that where issues are politically very sensitive, regionally or bilaterally, that's also likely to be the case at multilateral. But I think the recent initiatives are evidence that meaningful progress can be made and that the multilateral initiatives can build on what we've been seeing at the regional or the bilateral level. My last observation is that the GATS also sits within the wider structure and framework of the WTO. And this gives opportunities for institutionalised multilateral dialogue on the issue of the relationship between preferential services agreements and the GATS. And that is in itself is of value. As I'm sure everyone here knows, the WTO consists of 3 pillars: the negotiating pillar, the monitoring pillar, and the dispute settlement pillar. The majority of a WTO delegate's time is actually spent in the least spoken about pillar, the monitoring pillar. This consists of committees which administer the functioning of agreements, administer compliance with the agreements, and in practice give a forum for members to raise specific trade concerns or systemic issues of concerns to further dialogue on new challenges. For preferential trade agreements, before they enter into force, they're required to be notified to the Committee on Regional Trade Agreements, CRTA, which Gabriel discusses in his book, and in parallel to the Council for Trade and Goods or the Council for Trade and Services. On notification, the parties to the agreement are required to provide the Secretariat with information and data on the agreement, and then the Secretariat prepares a factual presentation on the agreement's key features. These summarise the agreement, they provide analysis, including on whether the preferential service agreement is GAP plus or GAP minus in various areas. And then WTO members can pose questions for the parties to the agreement to answer, and they're required to respond in writing. And then each preferential trade agreement is put on the agenda of the meeting with the CRT, and the parties are required to present on and answer questions. In reality, notification rates on preferential services agreements, which is the trigger for having this multilateral dialogue, leave something to be desired. if you actually look at the graph of notifications over time, you see the spike in 2021, which is when the UK left the EU and rolled over all of these agreements. But in general, compliance rates are not 100%. And the types of presentation also vary. Some are a very factual run through, and others are more discursive, seeking to draw out interesting features of the agreements and stimulate discussion. And from a delegate's perspective, so some are easier to engage with than others. My reflection is that these structures exist to enable a really dynamic discussion on the relationship between regional trade agreements and the multilateral system. And this has the potential to allow members to discuss features where they think an RTA includes innovations that could be drawn on multilaterally, and to build understanding of the barriers and the way that preferential services agreements seek to break these down, with the hope that this could build conceptual understanding for negotiations in a multilateral agreement. Perhaps the jury's out on whether it's fully meeting that potential, but I do think it's an example of the WTO as the value of the WTO as an institution within which the gap sits in trying to solve these issues. So to conclude, you'll notice that I haven't really answered any of Gabrielle's really hard questions on whether preferential services agreements do in practice generate new preferential market access, and whether they do in practice divert or create trade, and what that means for the multilateral system. Instead, I'll really commend his book on those issues, and I'll finish as I started. But the GATS continues to underpin the global system for trade and services, even if it sits alongside a growing net preferential services agreements. And it's in all of our interests to support efforts to enhance the multilateral rule book for services trade and to progress services liberalisation.
Thank you very much, Justina. Very interesting observation on the relationship between GATT and PSA. I'm sure we'll have a lot of questions coming from the audience, but perhaps I pass the floor to Panos, who I think is going to talk to us about chapters 4 and 7 of the book.
Yes, so thank you for having me. Thank you, Gabriel, of course, for the very, very kind invite. I got a cold last weekend. On Monday I couldn't really move, but I said I'm not going to miss this for anything in the world. So I have to not transmit any words here for later with the people that we're going to have dinner. I think that actually, as people were talking, many friends in the audience know that I have a very weak memory, but I remember that we're supposed to write a book together on services, all right? And then eventually, maybe because he thought that academics will take ages to finish this book, he said, all right, I'm going to do it myself. And he did it. And I think the only thing that I don't like in this book is the cover. I think it could be much, much better, right? So I think he spent so much intellectual effort in the content that we ended up with this. Otherwise, I think the book is amazing. It's a delight for academics, for sure, for policymakers, for students as well. For academics already, because like myself, because it shows us that we are in need of more policy-related work and realistic work as well. Right, and I think it was also a reality check for myself. Some people who are working on GATS in the room know that for years I've been arguing about an necessity test, that Article 6.4, so the reference paper that now is out, is against the mandate that existed, and I have an obsession almost with that one. Gabriel, at least, would say, and it is, of course, almost. Idealistic. It doesn't really, change any. It cannot really improve, let's say, policy in services, right? So we need more realistic work from academics. For policymakers, because it gives them a very accessible window into how services work, how they can also implement very specific and easy changes in during negotiations, right? So for several years earlier, we heard about scheduling and all that. Everybody talks about outdated scheduling, and we say, oh, you need absolutely to change, to update the classification, update the schedules, and all that. Here, I think you come with much more accessible and easy, let's say, fixes. I think that's very commendable as well. For students, again, I think that they may, by reading this, they may understand first that GATS is very, very relevant, and also that GATS can be an area where they can specialize themselves and be the new generation of students who, of policy experts or trade experts or working in this field, that can actually implement some of the ideas that you have there. So when it comes to this, international standards, this is an area that is very close to my heart, and also by reading your initial draft, made me think a bit of the stance that GATS takes and how, let's say, good it is compared to the TBT. Right, so the Technical Barriers to Trade Agreement has an obligation. There's an obligation actually to use international standards, and if you use them, then there is a presumption of compliance with the agreement. So what the GATS, on the other hand, has is a transitional provision in Article 6.5, which says, which provides that international standards should be taken into account. However, arguably at least, and of course you don't discuss this because this is very academic and maybe theoretical, this provision is not valid anymore as long as there is the reference paper on domestic regulation. Right, and the reference paper on domestic regulation takes maybe a more, again, a more realistic stance towards international, towards the use of international standards. What Gabriel discusses briefly but correctly and rightly is that essentially here we have a different approach. We have much more reluctance towards international standards. First, because there are very few international standards in services compared to goods. At the time, I think the anecdotal evidence also, or some discussion that I had with the division members, but Hamid told us more about that, was that at the time they felt that maybe the TBT approach is not something that we should have in the services, in the area of services. And this is something that also Gabriel says that, or confirms, this is the right approach even today, right? So contrary to what we see in PPAs, where there are maybe hard to type obligations to use international standards in the area of digital trade, trade protection, data protection, privacy, etc. Here, a much more, let's say, flexible approach with no ex-ante commitment towards the use of international standards would be the right one. One, of course, let's say, important point that Gabriel makes is that there is a mushrooming of international standards. Private organizations who create international standards. So there, one of the let's say questions that I still have, and we could discuss later, is whether international standards is or all these private standards, they create a certain framework which is very, very complicated. And of course, this leaves a certain leeway to adjudicators, which we cannot predict. Right? So one of your proposals is, for instance, just let case by case WTO adjudicators decide when an international standard comes in front of them, decide whether this is relevant or not for the case. But there is also a certain danger there that they may use or they may consider as a relevant standard, a standard which, let's say, doesn't have multilateral consensus. If we take the reference paper, it talks about openness and transparency, right? And there can be standards. If we take the example of goods, there can be standards which where all WTO members are represented, right? But still, for whatever reason, they do not represent multilateral consensus, right? So In retrospect, we would say that they are not really, they cannot be considered as adapted or as accepted, by the international community, right? There is not even, let's say, a qualified majority of states that would accept it, right? So at ISO level, we have the 75%. You could consider that not even this is there. So what happens with those standards, right? In Argentina Financial Services, there was clearly a standard which was not adopted by all WTO members, right? But imagine a case, as I say, where all WTO members, let's say, could participate in this particular organization, the specific organization, but still there are issues with respect to coherence, with respect to relevance, and all that, right? Can we trust the judges, the WTO, the panel members now? But probably disappear. So can we really trust the panel members to do this type of job, right? I think we don't really take a stance, all right? Because on one side you say this, but on the other hand you also say that, well, we can also have, and I think that's the approach that I would subscribe to, we can also have a TBT committee-like decision by the Council for Trade and Services, or they could come with services-specific criteria, additional criteria to what we have at the TBT committee decision, which would, let's say, give us a framework, give also to the adjudicators a framework, right? Very similar to what happened in the US Tuna 2, where they could be led, right? They could have much more input from members. And I think this is the right approach, and correctly you raised that. I would skip because I think I don't have much time. All right, I'm already. How much time do I have?
No, I think a couple of minutes.
A couple of minutes.
Yeah.
All right. So I'll go to development because I have a lot on standards, and I will not cover development. So when it comes to development, there again you take a very pragmatic, realistic approach, and this is, I think, commendable. So there was a lot of discussion about the LDC waiver, for instance, and there you have a grounded study of a reference to a grounded study by UNCTAD suggesting that actually this didn't work. And I think the graduation approach that you proposed and you discussed earlier is the right one. I don't know exactly how it's going to happen. I think Thomas Coutier in a given moment wrote something about it, but this didn't fly. Maybe Laurent did. I'm not sure, right? So there are more experts in the room and elsewhere that can maybe come up with a mechanism that will have this, that will allow for the implementation of this graduation mechanism with a locking in future liberalization in case of development, right? This is how I understood it. And I think it's a good idea because currently, as you say, there is, a self, every country decides for itself where it is developing or not. And this creates certain distortions, let's say, in the discussion relating to development. The mechanism that you propose of suspending commitments, I think, is very interesting. I would like to hear from Hamid, of course, how realistic this would be, right? Because I think it's almost heretic. People would think that commitments are there, they are locked in. We cannot suspend commitments. We know what happened with, for instance, the US efforts to change their schedule after the Gambian case. It takes ages. I'm not even sure that actually this was resolved. So this is a discussion, I think, that's very, very interesting, and it needs to come from developing countries, right? This is, I think, something that we're currently missing. So, a more pragmatic approach also from developing countries. Of course, currently you are a negotiator. Maybe you cannot say that, but again, their academics probably could say something similar. My personal approach, of course, is negative because I think also in the developing countries there is a certain monolithic view when it comes to development, at least in some countries. But hopefully, let's say, your book will instigate a discussion as to how we can address development-related questions in a much more realistic way that can collect consensus from the members. Thank you.
Thank you, Panos. So, Hamid, you're gonna give us a few comments on chapter 2, although Panos has already asked you so many questions. You made your life very difficult, but maybe we can keep that.
Before
We can keep this for the Q&A.
Exactly. And I would just make a few brief comments on chapter 2, which I was very happy when I read, because actually I think Gabriel did an excellent job in looking at this function, the negotiating function, in a very realistic but also very effective way, because this is a legal system. And like any legal system, there is a balance between the judiciary and the legislature, right? So to speak. And the negotiating function in the GATS is the legislature. And it is so critical, even in the original design of the agreement, because at the time of the drafting of the GATS, we were looking into the future that we knew the direction, that the direction is going to provide a lot of innovation, technology-driven business models that will call for regulatory responses, and there would be conflicts of interests between countries and all this. So, but there was a lot of unpredictability. The only thing that was predictable at the time was unpredictability itself. So in terms of treaty conception and drafting, the only way to address a situation like that was to build into the agreement a robust negotiating function. That's why, this is Gabriel captured, he said, you do have a provision which says we shall pursue progressive liberalization through successive rounds of negotiations, the first in 5 years and periodically thereafter. I will come to the impasse, because this is actually heartbreaking when you think about, okay, in 30 years we haven't done one. Right? But really, it is the negotiating function. And for an agreement like the GATS, I mean, as Gabriel mentioned in the beginning, it was quite innovative in some serious ways. The first thing is the coverage of the agreement, which covers the supply of services. It's trade, but it encompasses cross-border factor mobility. So investment flows are an essential part of services trade. I mean, 2/3 of global FDI flows today are in services. So when policymakers think about trade and services, they need to think about other policy areas that would have to be coherent with their position. And then it's the structure of the agreement. Gabriel mentioned this also in a very nice way, the development aspect of the agreement. It's interesting that you will not find the term special differential treatment in the GATS at all. It was deliberately replaced by a variable geometry. And this is actually, this informed the architecture of the agreement itself, whereby you have individual schedules for each member that determine the level of adherence to the most important disciplines and obligations in the agreement. It's not just market access and national treatment and additional commitments that are scheduled or the consequences of negotiating outcomes. You look at how many general obligations in the agreement that kick in only for services listed in your schedule. Cross-border data flows obligation in the telecommunications annex is a good example. Now, that kind of variable geometry was because of the realization that developing countries were no more homogeneous. There has to be that variable geometry that would allow for individual flexibilities as stipulated. And it has to be based on negotiating outcomes. And one of the things actually when it comes to development, I mentioned this because it's very, very relevant to the negotiations. The discussion at the time was S&D was dysfunctional. Everybody was disenchanted. Then the question was, okay, how do we ensure that developing countries benefit from their participation in the system? So what is the purpose of S&D? Is it an exonerating concept that simply allows developing countries to undertake less obligations? Or is it an enabling concept that allows them to integrate? Of course, the answer was clear. It's the second. Therefore, you find Article 4, the title is Increasing Participation of Developing Countries. And then, how do you achieve that? Through negotiations, through negotiated outcomes, through commitments by all members, which is quite significant. This is very central to the negotiating function, that developing countries undertaking commitments is beneficial for them because, among other things, it attracts FDI, and FDI leads to transfer of technology, and then it helps developing countries build their own domestic services capacity and competitiveness. I mean, I remember 2002, for example, Egypt, for one, it's a country I happen to know something about, went to the WTO in 2002 and unilaterally submitted a schedule on basic telecommunications, scheduling full market access to national treatment and the reference paper on regulatory principles and all that. Why? Because they wanted to attract investment. Okay, so there is an important development element here. And I like very much what Gabriel put in chapter 2 about the negotiating function, about what to negotiate. And what to negotiate is, of course, market access and the i.e. restrictions. But the interesting bit that he referred to also was Article 18. Article 18 is, I think, is a very, very interesting subject that goes a long way because it captures, as he said, the concept of how you make regulatory measures least trade restrictive. That's the objective. How do you, without interfering with regulatory sovereignty, because the agreement in the preamble says right to regulate, right? So how do you not interfere with the right to regulate, but at the same time ensure that regulations are not hijacked to disguise restrictions or to be more trade restrictive than necessary? That was embedded in Article 6.4, but the relationship between Article 6.4 and Article 18, they were born at the same time. They were two parts of the solution to the same problem. And while you go through the negotiation of 6.4 disciplines, which we just scratched the surface of, you can negotiate isolated solutions for problems and schedule that under Article 18. Now, the reason why I like the way Gabriel did it in the book is because it is important for policymakers, it's also important for businesses. Because one of the things that I think we need to do more is inform the business community of the opportunities that can be available in the GATS with the toolbox that the agreement has in solving specific problems. But that requires the kind of dialogue which we used to have in the old days, but it doesn't happen anymore now. That's why you have these kind of sort of convictions. There are some narratives that have just taken a life of their own, whether it's about the moratorium or about, I'm not going to go there, don't worry. But the business community needs to understand that there are solutions for problems that they have, but you need to identify the solution. Sorry, the problem first, and then go to the solution. Now, one other thing that Gabriel touched upon, I think, which is causing a lot of tension now is how to negotiate. Not just what to negotiate, but how to negotiate. And this kind of political tension about plurilaterals is quite, I find it fascinating because if you look at the history of the system over the past 75 years, plurilaterals were the rule, not the exception. Even tariff rounds under the GATT were by definition conducted by subsets of the members. Now, and since the establishment of the WTO, we've had a lot of plurilateral negotiations. Financial services, telecommunications, World IV, now domestic regulation, and then on the good side, we had ITA 1, ITA 2. We were celebrating the launch of the EGA, the Environmental Goods Agreement. Now, why all of a sudden plurilateral negotiations have become a taboo? Now, what I like about what Gabriel did is that you see that distinction there between plurilateral negotiations and plurilateral outcomes. Because there is a very confusing generalization when people say, oh, we should allow more plurilaterals. What is plurilaterals? Is it the negotiation or is it the outcome? They're two different things because so often you have plurilateral negotiations that produce multilateral outcomes. This actually has been the practice all along. So he unpacked this distinction, which I think is the gateway clarification to discuss how do you negotiate. And plurilateral negotiations with multilateral outcomes is the way to go. That's why in the GATS itself, as you cited, Article 19.4 calls upon members to engage in plurilateral negotiations. Not only that, but I like your reference, Gabriel, to Annex C of the Hong Kong Ministerial Declaration, which for the first time innovated plurilateral request offer negotiations. And on the basis of that, there were plurilateral groups on specific sectors and modes and areas of negotiations, with groups doing what? Drafting collective requests. Now, why all of a sudden today we're saying, oh, plurilaterals are fragmenting the system? No. We're talking about outcomes, that's a different matter, because that's a non-MFN route, which actually raises questions in my mind we can discuss later with respect to both investment facilitation and the e-commerce text. Now, the last thing that I'm going to mention, because I think we're running out of time, is Gabriel also said, okay, what next? There's something specific to suggest. And I like that very much. And this kind of approach, is the way, maybe I'm being subjective, but that's the way I think. You need to know where you stand first before you say where you're going to go. It's like the GPS. You switch on your GPS, the first thing it tells you is your current location, right? And then you decide where you want to go, and then it gives you options, right? So one thing that Gabriel said there, which actually I have been advocating now for some time, is why not have the next JSI on services? I think this would be a no-brainer because of the following reasons. First of all, we haven't finished one single round in 30 years. Second, you could do it plurilaterally, it's mandated. Third, you can actually capture a lot of the autonomous liberalization that has taken place over the past 30 years. There are a lot of many low-hanging fruits. So you don't need to inflict the pain of new liberalization to have a negotiated outcome. And then, finally, you can look at some of the things in the schedules that need updating, such as classification. And classification here is a matter of contractual obligations. How are you going to draft your commitment? What is the sectoral scope that you are committing? And one of the flexibilities in the GATS actually is that it does not legally require any kind of approach to classification. The only thing it requires is that you have to be clear about the sectoral scope that you're committing, because that's your contract. Now, whichever way, I mean, it's true that all WTO members except one follow the CPC. And that one, of course, is the US. They don't follow the CPC. But you can follow whatever system you want, but define what you have there. And there, I think a new round of negotiations, we started discussing this during the Doha round, the relationship between you and all commitments. That was a big discussion. And one of the benefits is cleaning up or updating some of the classifications through negotiations, because it's all contractual. But then you wrap this up nicely at the end and say, okay, guys, if you really want to be serious about it, you have the tools there, and there's a way of doing it, and it's not very costly. But congratulations. And I think I would suggest that this would be a reference on the bookshelf of negotiators, policymakers, academics, and anyone who's interested in the subject. And congratulations, everybody.
Thank you, Hamid. I think a lot of food for thought and much more in the book. This was just a trailer, so go and read the book. But I want to open up for a few questions. I think we have roughly 20 minutes. So maybe we can collect a few questions that we will open up to the panel. And maybe you want to introduce yourselves when you ask the question. I have a microphone here. We haven't actually been using it.
It's
I'm used to
okay.
my,
Everyone can
my
hear you
style
online.
loud enough. I hope everybody was able to hear as well, but if you,
Just give me 1 moment.
Yes.
So, if you take a few at a time, that will work best. And then
okay,
we swap it up.
so let's start from Lauren, and then we have Gary.
Well, I'll start while you're doing that. Well, I'm inspired. Lauren Bartels from Cambridge. So, with that in mind, and with all reference to the realism that is in your book, which I haven't read, but I've heard a lot about now. I will, particularly now that I see that it's not huge and it's readable, so that's very attractive as well. There's obviously a problem with the negotiating function, along with everything else, and this objection. We obviously know the countries that object all the time to this. Who plurilaterals doesn't help, and so on. But there's also an absence of dispute settlement. Very few cases on GATS, very little on MFN, for instance. I mean, there's obviously a lot of low-hanging fruit that could be gathered by some, targeted cases invoking MFN, which covers the lot, of course. Even if you wanted to take pot shots at, not particularly Article 5 consistent FTAs and bring in some digital, I mean, there's so much that could be done in terms of non-rule compliance. And because that's not to mention recognition, because none of that is happening, I just wonder whether there's not only a lack of interest by businesses in this theology that we studied and created in some cases, but is there also and I guess, Justin, I'll put you on the spot, but you and Gabriel do this for a job now. I mean, is there also a lack of interest by governments in actually pushing this ahead? I don't know. It's an open question.
You just speak into it more like this.
Thanks very much. I don't wish to put a burden. I'll yell. I don't wish to put a burden on the panelists, but rather the audience. So as Hamid will painfully recall, Article 15 of GATS requires an agreement on subsidies, which never had, there's some really cool stuff done, thanks Hamid, but nothing ever happened. Is there any interest, well, I have two questions, is there any interest in resuming that? And secondly, I'm working on a project, and if anyone has any information on subsidies and services, which is really hard to come by, Dr. Morgandi knows where to find me. I have one more comment on one little tidbit following Lorenz. So I was applicants counsel in Mexico Telecoms, which raised huge numbers of issues, which are there in the public request for consultations and then a panel. And most of them disappeared. So there's reasons why these issues don't get litigated.
Hello, my name is Sergei Ripinski. I happen to work with Gabriel, and after listening to all of you, I feel very lucky to be working with Gabriel. My question was, well, first of all, it seems like Gabriel has come up with a checklist, basically, that countries, governments can use when they finally decide to do something progressive in services. But I understand we are not in that point, and maybe not in the foreseeable future. My question is actually factual. So at some point there was an initiative, a plurilateral initiative driven by a group of countries called the Very Good Friends of Services, I believe that was the name, who were supposed to negotiate something called TISA agreement and show leadership in that space. So I don't know what happened to that agreement. Is there anybody who can explain why this failed, if it did fail? Thank you.
Addressing any of the questions, Hamid, you want to kick off? And then we might have a second round of questions.
Sure. Starting with Laurent's question about government's lost interest. I think the problem there, and Gabriel alluded to this. The services impasse is not because of services. That's the reality. I mean, what we had during the Doha round was very revealing. It was obsession with agriculture. And then I remember in 2008, July 2008, we had what we called the signaling conference on services. Why? Because we were so close to agreeing on modalities for agriculture and NAMA. And then it was the European Union who said, well, we're not going to agree until we see what we're getting on services. We only have initial offers that are not good enough. So we had a conference of 32, 33 ministers who said what they're going to offer, what they're ready to offer, basically promises, but ministers, promising ministers. And I remember at the time I did a summary of that, but without saying who said what, basically sector by sector saying what was offered. And I remember at the time, I was sitting, it was in room E upstairs in the WTO, and Susan Schwab, who was USTR at the time, was sitting beside me. And at the end, after India came forward with really, really substantive improvements, including lifting foreign equity participation limits on telecommunications, and she blinked at me and said, this really exceeded our expectations. And then the whole thing collapsed, not because of services, but because of agriculture, SSM on agriculture, and other things. Now, the problem is with the passage of time, the private sector lost interest. And basically the leadership in any negotiation comes from governments who listen to their private sector. You look at how the system was built, right? That's where the thought leadership comes in. And I think the problem with the WTO now is one of leadership deficit. The US is not going to come back doing what it used to do. The system needs a new kind of leadership. It's probably going to have to be coalition-based, which is more complicated to put together. But even then, that coalition needs a champion. And the only champion I can think of now is the EU. But the EU have their own internal issues. And you don't know where this is going to come from. And that leadership, actually, when it happened in close contact and collaboration with the private sector. Because the private sector are the end users of what we're doing. By the way, the private sector are not just interested in market opening and liberalization. They want certainty. You know, the biggest achievement of the system is the stability and predictability, because this is how they make their investment decisions. So the answer to your question, Laura, is that lost interest because I think they're distracted now. We're getting into a phase where I think what we're going to see is a bit of a change of attitude from the US government, change from neglect to hostility, probably. So it's not a happy situation. And this is why I always say that those who care about the system should get together and save it before it collapses, because this one collapses, we will never be able to create anything like it in our lifetime. That's the reality. Gary's question is very interesting, because you're right, there was lots of discussions, but those discussions came back full circle about what is the scope of what we're trying to achieve, because having subsidies disciplines is something that was inspired by the subsidies agreement on the good side. But then the two starting points for both agreements are different, because subsidies are excluded from Article 3 of the GATT, while actually that's not the case for the GATTs. And when subsidies as a measure affecting trade and services is covered by MFN and covered by national treatment, then the question in those discussions was, okay, what non-discriminatory subsidies do we think need disciplining? And then that immediately would get you into conversations about services or social purposes and social welfare and for other non-trade policies. And then it becomes a very intrusive conversation. And that's why, you know, the discussion actually faded away, saying, okay, if we're worried about conditions of competition, that's why we want to go for subsidies disciplines, then we should negotiate more national treatment commitments. That this is the solution. Now, the last question about TISA collapsed because of regulatory diversity on digital trade, particularly privacy. This is actually a very good example of how regulatory diversity needs a creative approach. And when you look at the US and the EU, it's a very good example, because these are probably the two most sophisticated regulatory jurisdictions when it comes to digital trade. When something like privacy, the starting point for regulators are different. In the US, it's consumer protection. In the EU, it's human rights. There you go. Regulators are going in different directions now. So the question becomes, how do you bridge such regulatory diversity while respecting regulatory sovereignty? It's a challenge that hasn't been actually addressed properly yet, because we're not having the right kind of conversations we should be having. But that was the main reason why TISA actually collapsed.
Anyone else? Yeah.
I'd like to add something on Lauren's question about dispute settlement not being used to clarify trade and services question. I think when I was looking into digital trade and digital services trade, I asked the same question. Many of these things, from the purely technical legal perspective, if you apply the GATS, we know the answer to these questions. But the input I received is that members are hesitant to litigate digital stuff, especially now. It's because it's like throwing stones in glass houses. Like no one wants to see this clarified because it just impinges on their regulatory autonomy that they have now. And I think even more like in recent years, this was when I discussed it in 2017, 2018, but even now even more, even the US wants more the regulatory sovereignty. I mean, they pulled out of the digital discussion because they want to be able to break up big tech at home and not be constrained by any new WTO rules. So I think that kind of also explains why they just don't want to open that box of Pandora.
Yes.
So I think actually that the state-to-state mechanism, social mechanism, cannot work for services. In a paper, I argued for a mechanism that could be decided upon in the Council for Trade and Services, but then which would be implemented domestically, where they get a separate, a fast-track, let's say, mechanism, service suppliers in the domestic jurisdiction, right? And they raise their concerns, right? This would be, for instance, through the inquiry point, where there is a mechanism, and there are several, let's say, GATS provisions to do that. Now, typically what we say to our students is that we don't have many cases because we have outdated schedules, right? And the schedules actually do not represent reality. But it is obviously much more nuanced than that. I think one reason is that we have an exception on subsidies for certain countries. Another reason, I think, but you know, the panelists will correct me, is that I have the impression that the US will not bring any cases on services anymore, right? After China financial services, I think it was a big blow there for the US. We didn't expect it. Argentina financial services was also a case where there's half of the pay body report, which shouldn't have been there. And then in terms of, as I said, in terms of schedules, I get the impression that simply there is no interest to bring cases because they don't reflect the reality of what exactly you have in the domestic level. But obviously there are more issues than that, and both Hamid and Ines talked about.
Yeah. Just some brief comments on those questions. On the question from Ivan, have governments, have stakeholders lost interest? I hope, and I think no, governments haven't lost interest. These challenges matter. Making the most of digital trade, bridging gaps, regulatory convergence, they matter. And it's important that governments continue to maintain interest for societies of economic growth. If it's any faint hope, I mean, the impasse that Gabriel and leaders described is really different. These initiatives, the joint initiative that arose in the MC12 conference, they're in the services space. This recognises the value where the value lies. On stakeholder engagement, I think there are voices that we understand and are really engaged, and that was certainly my experience in Geneva with stakeholders that we interacted with. But really, services trade has a much greater capacity beyond those, really sophisticated stakeholders to stimulate economic growth, to lift societies out of poverty, to diversify exports. And I think there's more that we need to do to convey that message and to help developing countries, small traders, to understand the benefit. The recent World Bank WTO report is a good starting point in that respect. I think. I agree with some of those reflections on dispute settlement and glass houses, and it's a big investment of a government to bring a case, and you want some degree of certainty that it's going to be worth it. So, where there have been lots of cases that have gone before in the good space and things are well trodden, you have a fair degree of certainty that there's going to be an outcome, and that's an easier decision to like I say, that's one reflection.
Can I just make a
Yes,
follow up
yeah.
on this? Because I think Justine made a very important point about the mindset of governments. And I think something is missing there in terms of the conversations that take place. Because you're absolutely right that there are so many things that are cited as objectives, desirable objectives, inclusive trade, reducing poverty, diversification, competitive development, sustainability, inclusive trade, women's empowerment, and you can see a services string running across all those. Not only that, but ministers at MC13 said we are committed to reinvigorate the services agenda of the WTO. So how do you connect the dots? So how do you have the right kind of conversations in the WTO, which connects those dots and then leads to something?
So it's 8:03, and I want to give a chance also to Gabriel, perhaps, to, share with us any final thoughts.
Just one question on TISA that you mentioned. I think it's good to compare, to bear in mind what is TISA as a closed negotiation outside the WTO, where the outcomes will be shared just between the participants, where accession is closed, even China tried to join and was blocked, to what would be an open plurilateral negotiation in the context of the WTO, which is under the limelight, it's transparent, it's open to anyone who wants to join, and the outcomes will be on an MFN basis. So when we are concerned about plurilaterals, this scenario is much worse. So it's important to bear in mind that. But just to say huge thanks for the discussions, for the people present today and online. And yeah, thank you very much.
Well, I think I was gonna say in 10 years you wait for 3.0. Gather again, but there are nibble, a bit of wine, some drinks, so join us to keep the conversation. Thank you, everyone.